appeal for the state of Florida is now in session. Institute for Procedure, presiding. This is for this court. You give attention, you shall be heard.
Morning, everyone. I'm Judge Torpey, as the marshal indicated. To my right is Judge Griffin, the dean of our court, the senior member of our court. And to my left is, we're pleased to have today our former Chief Judge, Emerson Thompson, who is now a senior judge, and he'll be sitting for Judge Monaco today. We have 3 cases on the docket. We'll try to get through them all this morning. I noticed that the last one is a 10 o'clock case. We'll get to that probably early if the lawyers are here and prepared to go. The first case is a criminal case, Rachel versus State, and if counsel is ready to proceed, you may proceed.
Thank you, Your Honor. Good morning, judges. Richard D'Amico, Ormond Beach, Florida, representing the appellant Albert Todd Rachel. In my many years of practice, it's been 35, I've noticed that every criminal defendant who is at the point of taking a plea that involves jail time always asks the same question, and that is, how much time will I serve? What is going to be the actual time that I serve? Just about everyone does that. And I think that our attorneys at the trial level have the obligation to give the correct answer to that client. And before he gets shipped off to state prison, he should know about what his release date is going to be. Now, in the past...
Isn't the issue in this case not whether he had given them the correct information, but whether he relied upon the error and that reliance induced him to enter the plea? Don't you have to establish that he actually relied on it and it induced him to enter the plea?
Well, he testified to that. He testified that he was told that he would serve just a little bit over 5 years, when in actuality...
Well, do you have to prove that?
Prove...
Do you agree that you have to prove that it was the defendant's burden to show that he relied upon this misstatement of fact as an inducement to enter the plea?
Yes, I agree. I do agree.
Now,
and I think,
wasn't there conflicting evidence on that point?
I don't think there was anyone other than the defendant that could actually answer that question.
Okay, now, doesn't the fact that he said during the plea colloquy that he wasn't promised anything that was not, in the plea document as an inducement to enter the plea, doesn't that contradict what he testified to?
Well, no, I think that there are a number of things that are discussed prior to making a plea, and that they're not all necessarily, he didn't necessarily have to tell the judge all the things he talked to his attorney about that created this plea.
That's the purpose of asking the question, right? To avoid the potential that he's going to come in later and try to set aside the plea based on some promise that he was given that, that was erroneous.
Well, if that were the case, because that question is asked at every plea hearing, if that were the case, no defendant would ever be able to set aside one of these pleas on the grounds.
Well, isn't that the purpose for the questions? I mean, you got him under oath. Mm-hmm. Okay, I want all the promises that induced you to enter into the plea. I mean, there's a difference between a promise that's made that is just a promise that doesn't induce reliance, and one that is material enough to induce reliance. So the judge says, look, I want to know everything that you were promised to induce you to enter into the plea, and he's under oath. Isn't that the appropriate time for him to reveal those promises so that can all be fleshed out in advance of the plea?
Had that happened, he probably wouldn't have pled, because there was some disagreement. There was some hesitation on whether to take this plea. But as far as what you're saying, I agree there are a number of things that go into a plea, but I don't know that the defendant would know at that point what he's supposed to say. I mean, he had talked to his lawyer. His lawyer told him, you're going to do about 5 years. He's standing before the judge. I mean, I don't know.
What you told me just a minute ago is that the most important thing in the defendant's mind is how much time he's going to get.
Yeah.
I would think when the judge is asking him, did anybody make any promises? He's sitting there looking at a 7-year, the paper says he's going to get 7 years. Somebody promised him he's going to do a little over 5. I think that would be the appropriate time for him to say, well, Judge, yeah, I was told I'm only going to actually have to sit in DOC custody for a little over 5 years. But he said no, I wasn't made any promises.
Well, I think I see your point, but I think it's stretching it to have that criminal defendant expect to say that. He had confidence in his lawyer.
Let me ask a question. It's curious to me. What is the actual time that he is projected to serve?
Okay, it's a 7-year sentence with basic gain time at 85%. It's 5.95 years.
Okay.
That would be 5 years, 11 months, and 12 days. It's basically 6 years.
Okay.
And that is the problem that
Okay, well, let me ask this. You've done criminal law.
Yes, sir.
If you're charged with a felony of the 2nd degree and the jury comes back with a felony of the 3rd degree, you appeal it and it goes back for trial, what's the maximum sentence you could get?
5 years.
If he goes back to trial on these charges, what's the maximum penalty that he is exposing himself to?
I think it would be 15 based on this charge.
It would be the resurrected charges as well as the charge he pled to and the charges that were in all process. Is that correct?
It could be depending on what the state does. I mean, I don't know what the proof was.
Certainly if they charged originally, they'd go back and refile the original complaint or the information, correct?
But it would all be based on the same incident, so I don't know that it would result in any additional
Well,
time.
there's an eyewitness, a confession, or a statement that he made to federal authorities in the Bahamas, and then you have immediate outcry. Is it in your client's best interest then for you to expose him to a severe penalty based on approximately 9 months?
Okay, well, number one is that he was also sentenced to sexual offender probation,
Absolutely.
8 years. And that's something that some people can't complete, or it's a very strict probation, so he could end up doing the 15 anyway. It may sound like it was a little bit better deal, but it wasn't that great a deal. The second thing is...
But your client understands that he could serve a greater period of time in the Department of Corrections
Yes,
if
I've
you
explained
win,
that.
go back, and the witness comes forward, identifies him, and that's not an issue, enters his statement if it's properly obtained, and that he would be convicted. And your client's aware of that, or are we going to do this again?
I have made him aware of that, Judge. But let me just say a couple of other things about that. There's some evidence on his side of this
understand.
also. Well, there's no DNA. They did DNA testing, and he didn't even get those results until after he was in jail.
I read your point on the DNA, but didn't he admit that he had sex with this 16-year-old girl?
Well, it was said in kind of a strange way, and I don't know that really matters. It has nothing to do with this.
It doesn't seem to me that DNA matters much if the guy admitted that he had sex with a 16-year-old girl. I mean,
Well,
that's a violation of law, right?
See, I don't think he said that. I think he said that I don't know the exact language, but it was, actually we quoted it in our brief, but it really, the case law that we gave you shows that it's not really relevant. It's a question of whether the attorney effectively represented the client. I mean, we can have, that a person can still have constitutional rights and have rights even if he was absolutely guilty. But that wasn't what he said. He said something somewhat in between. And trying to see if I can I'll find it for you on rebuttal as to exactly what he said. But we're not dealing with the guilt and innocence at this point. We're dealing with whether he was effectively represented. I mean, he may have wanted to go to trial. Well, right now he's telling me he wants to go to trial, that he felt that this particular plea arrangement, that he thought he was going away for just a little over 5 years. Then he found out on top of it, because his attorney didn't even know the difference between incentive gain time and basic gain time, that he might not get basic gain time for this charge, something that wasn't told to him. So when he got to jail, he found out about this DNA test. He found out that there was a deposition taken, which he didn't receive until a year later, and in it there was some contradictory statements, and all of a sudden he said, I really shouldn't have pled to this.
What about the defense attorney's testimony that he gave him a range and that it was about 5.7, and he's actually going to serve, as you said, close to 6 months. So you're talking
6
about
years.
6 years, I'm sorry. So So you're talking about several months.
Okay.
Didn't the judge give an opportunity for the defense attorney to be heard? Then it was a credibility issue. You have the letter to the family. Doesn't that support the judge's finding that the petition had no merit, the motion had no merit?
Actually, I think it's the opposite, and I'll tell you why. There are three different statements that were made by this attorney. Now, this is an attorney who's a member of the bar, he's a criminal lawyer, he represented this defendant. Within 2 days after the plea was entered, he writes a letter, which he says was written to the family, but it says, "Dear Todd and family." And he says, "I know that the time will pass quicker than you think, and you will be released from prison a little over 5 years." Now, that was addressed, the attorney tried to say this had something to do with the family, but the family isn't doing the time. I mean, Mr. Rachel's doing the time, doing the 5 years. So it was a little over 5 years, which Mr. Rachel testified meant, maybe a few weeks or a month. Then he made a second statement on February 15th of 2008. This is a letter that's attached to the response by the state. And in that letter, he says, I told him at the time he would be serving something between 5 years, 1 month to 5 years, 7 months. And then in parentheses, he put 5.1 years and 5.7 years. So that was a different range. I mean, because 5.7 years is more than half. Then, when he testified at the trial, at the hearing, his testimony was, I indicated to him that he would be serving about 5.5 years, maybe 5.7 years. So you go from a little over 5.1 to 5.7, then 5.5 to 5.7. And they're all wrong, because the number is 5.95. It's 6 years, okay? Now, we could say as well...
The trial judge determined that he didn't rely on that, and that's really what the issue is on appeal, right?
Well, yeah, I mean...
The trial judge determined that if there was an error, your client, it didn't induce him to enter the plea. That was the trial judge's finding, that it did not induce him to enter the plea.
Well, I don't know...
The lawyer testified that he didn't think that was what induced him to enter the plea. He thought that, based on his conversations, the guy knew he was guilty. He knew he was guilty all along. It was always going to be a plea. And the trial judge is really the one that is in the best position to decide who's lying and who's telling the truth, and he believed the lawyer, right?
Well, the lawyer made 3 separate statements, and I don't understand how he could ferret those out. And I don't think there was really substantial evidence, because the figures are so different. They're constantly changing. And if you look at the cross-examination of the trial counsel, he didn't know the difference between basic and incentive gain time. So for this guy to take the witness stand and say, I would have changed my plea, I would have not pled to this had I known all this, it's not out of the ballpark. And how can, I guess, the attorney get into the mind of the client and know what he would have done had he competently represented him? I think the only one that really is capable of doing that is the defendant. And there are some cases that need to be tried. Here's a guy who thought that, you're saying he's guilty, but he's not. He's thinking he's not guilty, and he might go to trial, but for these errors, it didn't happen. I understand your concerns about this, but an attorney can't make 3 separate statements of what he said, none of which are correct, okay? And then the trial court just say, well, I'm going to believe the last statement that he made.
We'll save a couple of minutes for rebuttal.
Sure, I will. Thank you very much.
May it please the Court, my name is Pam Cole. I represent the state of Florida in this appeal. During the hearing, the defense attorney said, we did discuss that, because he asked me the question, how much time? He said, but I just kind of guessed. I didn't give him an exact figure. He said, the defendant always wanted to plead. He just wanted to put off his incarceration as long as possible. So he said, he admitted he just guessed when he told him how long he might be serving. During the hearing, the defendant said he couldn't recall if he had told the Bahamian authorities that if he had known that the victim was underage, he wouldn't have messed with her, is basically what he had said at that time. When they had said that you admitted having sex, he said, no, I never said that. But when they asked, well, didn't you say then that you wouldn't have messed with her if you known she was underage, he said, well, I don't recall. So I think, and then if you look at his statements, his statements, he kind of goes in as far as the evidence against the defendant. If you read the defendant's statement to police, I mean, he never really denies it. He keeps telling, well, I know something happened. I'm guessing she thought it was inappropriate or I wouldn't be here. And then I guess at one point he said something to the effect that, I guess she's saying that I forced her, and the cop's like, I never said she said that. So, I mean, we've got plenty of evidence against this defendant. I don't think the difference in a few months would have changed his mind one way or another. The defense attorney told the judge that this defendant always intended on entering a plea. There was never any question of that. So whether or not it was 5.7, 5.1, or 5.11, this defendant was entering a plea. This court doesn't have any questions?
All right, thank you, counsel. All right, Mr. D'Amico, you got about 2.5 minutes left, sir.
Thank you.
I won't start the clock till you come back to the podium.
I'm just trying to find one thing.
All right.
I'm sorry.
No problem.
I just want to respond to two things the counsel said. First of all, there was no reason for the trial counsel to guess. This is arithmetic. Matter of fact, there's a point in the record where I asked him, I said, well, maybe this is an arithmetic error. He didn't even understand 0.85 times 7 years. But, well, I guess. I mean, this has been done now since they changed the law. Every attorney says you're going to do 85%.
I think the record's clear that he didn't understand game time.
Okay.
I mean, I think you all made that point.
And then counsel said something about it in a few months. It's really, in the eyes of our client, almost a year, because you're talking about a little over 5 years as opposed to really 6 years. And the last thing I wanted to cover was this. This question about, what he had said, and it's in the record starting at page 24, where the question by the state was, isn't it true you told him that if you had known she was underage, you wouldn't have had sex with her? Answer, I never said I had sex with her. Or you wouldn't have messed with her, I think is the way you put it. I really can't recall, sir. Now, did you ever tell Mr. Eddington that you had sexual relations with the victim in this case to a certain degree? To a certain degree? Yes, she refuted what I told Mr. Eddington in a deposition which I had never read. But you told Mr. Eddington that you had sex with the victim. No, I never said I had sex with the victim. And it's, well, you just said to a certain degree. Answer, I said we reached a certain point. She said, no, I can no longer do this. I said, fine, and I left. But you don't know what the this is. You don't know exactly what was going on. And it is equivocal enough that he might have well taken the chance to go to trial, especially since there was something in that deposition. And unless there's anything else, I thank you.
All right, thank you, counsel. Thank you both.